Hi there, it's David Carter again from Carter Injury Law. So now your case has gone to a new case phase, demand and settlement negotiations. What this video is going to do is explain the next steps and how the demand process works. Here's what I'm going to cover. I'll cover how we will be negotiating with the insurance company on your behalf and the potential outcomes of those settlement negotiations. So we've gotten all the medical records and the medical bills that we know about. What else have we done? We've scoured through those medical records. We've put together the medical bills into a chart, a spreadsheet, and we've calculated the total amount of medical bills. And we know the total amount of charges, payments, adjustments, and we know what you owe on those medical bills. And that's very important when we talk about settlement numbers, right? Is what you actually owe in medical bills and what you owe and what your medical records show at this point in the case. So I said this in the last video, but I want to say it again. If you think there's a doctor that you went to that we don't know about, it's very important that you tell us now. The insurance company that we negotiate is only going to take certain things into account, and they're only going to take into account what we provide them in this demand package. So if something is missing, like a medical record or a medical bill, they're not going to adjust their value of the case to reflect that. We're going to need to provide it to them. So it's very important. And we do a great job of getting everything you told us about. But if there's, hey, I went to a doctor last week, a new doctor that I didn't know, you got to let us know if we're missing something or if there's a doctor you didn't tell us about, just to make sure we're going to get full value on your claim. So here's how it works. We write an aggressive letter on your behalf to the insurance company, letting them know what we think your case is worth and why we think it's worth that. We outline all your medical records and treatment. We show them the medical bills. We discuss liability, right? We discuss how the accident happened. We discuss the coverage, right, that we talked about at the beginning of your first case phase, the coverage and liability investigation. And we point out why it's the other person's fault and why they should pay a certain amount of money under the coverage that they have. We will send this to them on a CD through the mail, and we will also, if we can, fax them a copy or email them a copy of the demand letter. So letting them know, hey, all these medical records and bills are coming on a CD to your office. From the date of our letter, we give them 30 days to respond. I'll be honest with you. That does not necessarily mean that you're going to get an offer or a response within 30 days, but usually it does. If you're dealing with a government entity, for example, right, they're usually going to take at least 60 to 90 days to even respond with probably what's going to be a frustrating offer or just some, kind of meaningless request for more information that they're not taking seriously. So it can be very frustrating, and for us as well, because we're spending a lot of time. Sometimes these insurance adjusters are out on vacation and they'll ask for an extension. And so we'll oftentimes give them this extension so that we can show to the insurance company that we're doing our best to try to resolve this case without having to file a lawsuit against their insured. Sometimes they give us no choice, but we want to at least show, hey, we're acting in good faith here. The insurance company, we can't control what you do, but we act as good actors. If you're dealing with a large trucking company or a giant corporation, for example, who uses a third-party claims administrator, sometimes they're not even going to respond at all. So we get these sort of just no response to our demands at all sometimes, and this forces our hand. We just file a lawsuit. In most cases, we should have a response to your demand within 30 to 45 days from the date of our letter. So 30 to 45 days from the date that we send it out, we should have a response for you, but again, there are different options that the insurance companies will take. So from there, a number of things can happen. First, and probably the best possible outcome, is the insurance company agrees to tender its policy limits. So what that means is that the insurance company is agreeing to pay the maximum amount of coverage that they have on that particular insurance policy. What that means is that the insurance company is agreeing to pay the maximum amount of coverage that they have on that insurance policy. The second potential outcome of this demand letter is that they make you some sort of reasonable settlement offer. So let's say the policy limits are $1 million, but your case isn't worth $1 million, but they offer you a reasonable settlement number. So we'll take that to you, we'll discuss it with you, and then we'll go back to them to try to negotiate a satisfactory settlement for you. We have a lot of experience doing this, so we can usually tell if they're trying to be reasonable based on this first offer. Okay. The third potential outcome is that they, deny the claim or say, hey, we're not paying you anything. And this is more common in slip and fall and premises liability cases, or any kind of case where they think you're over 50% at fault. So sometimes it happens in intersection car accident cases, but they just outright deny the claim. The fourth potential outcome is that they're going to ask for more information and refuse to make an offer. So insurance companies and their attorneys are famous for three things: deny, delay, defend, right? Triple D, deny, delay, defend. In our view, this request is essentially a bad faith settlement offer, because in our experience, all they're doing is trying to delay your claim. So they say, oh, we need 10 years of your past medical records and this and that. The longer they can keep the money in the coffers at the insurance company, the more money that they can make off their investments. So they don't want to give it to you. They want to keep it. They want to delay your claim. So it is in their interest, absolutely, to hold that money for as long as they can and not give it to you. We view this as a way of them doing that, and we don't believe that these requests for more information are actually any kind of good faith investigation into the merits of your claim. So most of the time, there are exceptions, but we will likely advise you to just move that case straight into a lawsuit to move things along, right? So then they can get whatever they want in discovery. Now we have a judge moving the case along. We're under a case management order. We got to go. They don't get to just sit on it. There are times, though, where it does make sense to give them the information that they're asking for and continue to try to negotiate if we think they're being reasonable. It's rare, right, dealing with insurance companies. But so the fifth possible outcome of our settlement negotiations is that they make you a lowball settlement offer. A lot of times, in our view, what a lowball offer constitutes is an offer less than what you owe in medical bills, right? As a starting point, we think that's kind of a non-starter. If you're going to start below what my client owes in medical bills, where do we go from there? So if this happens, our advice is usually to file a lawsuit against them rather than try to negotiate, but every claim is different. The reason that we say, hey, just file the lawsuit is we don't want to give up much negotiation room in an effort to get them to a number that we think is going to be too low anyway. So let's give an example of this. If we're at $100,000, let's say we demanded $100,000 and they're offering $10,000. We know that, based on our review of the claim, we're going to get you to $75,000. So to settle the claim, that $10,000 offer shows us that they don't take it seriously and that we're never going to get there. So we don't want to give up room off of our $100,000 negotiating number just to be told by some low-level claims adjuster that their top offer, hey, is actually around $20,000 or $25,000. So now it just doesn't make sense from a negotiation standpoint, because we sort of locked ourselves into a $75,000 number and they're at $25,000. So they may later expect to settle that claim for $50,000, and that's not what we want. So keep in mind that no matter which option happens to you, it's your case, and you get to make the next decision about what happens next. The ball is completely in your court. You've hired us to be your legal counsel and to work for you. So what that means is we will give you our best advice at every juncture of your case. But we cannot and we will not make the decision for you, right? I'll give you my advice, and if you decide to go with my advice or an attorney in my office's advice, we appreciate that, but at the end of the day, we take it very seriously that you're the client and it's your case. We will relay every offer that we get and every response that we get from an insurance company directly so that you can make whatever decision you feel is right for you and your case. So again, we expect to have a response to our demand package for you within about 30 to 45 days, or maybe 60 or 90 days, depending on the defendant. If it goes past that 90-day period, it'll sort of trigger us to probably say, hey, we got to file a lawsuit if we want to move forward. And then after you get your offer, it will become a lot more clear to you what the future of your case looks like. Or once you get a response, it'll look like, you'll know what the case future looks like. What I mean by that is whether or not we're going to settle your case and get it wrapped up for you, which usually will still take anywhere from 30 to 60 days after the date of your settlement, or whether you will be faced with the decision of filing a lawsuit based on their response. And sometimes a lawsuit is a great tool to move your case forward and let them take you seriously and get more money, and sometimes a lawsuit might not be right for you. We will never file a lawsuit without talking to you first and explaining what the process entails. So, for now, rest assured that Carter Injury Law is working to maximize the potential settlement of your case. We're working with the insurance company to give them everything they need to make a fair and reasonable offer to you. Whether they do or not, we will keep you posted as soon as we know more.